So many of you have probably heard the headlines, but actress Blake Lively tried to back out of her recent emotional distress claims against the director after his legal team asked her for medical records. It's a good reminder of a basic truth in law. Once you file a lawsuit, you are stuck in those proceedings and you may not be able to easily get out of them. So while it may feel good, feel righteous, feel emotionally releasing to sue somebody you really dislike, it's important to make sure you know what you're getting yourself into when you start a lawsuit. For starters, a court is going to want you to have evidence showing that you can actually prove everything you say you can prove. And you might just get sued back by the person you're suing. And you'll be opening yourself up to discovery, which is what I want to talk about today. Discovery is a long and expensive process by which your opponent gets to ask you for documents and pry into parts of your life that you may have thought were private. So to be clear, I don't know who was right or who was wrong in Blake Lively's case, but it is a good example of what we're talking about today. In Blake Lively's example, when she claimed intentional infliction of emotional distress, or what we call IED, she was putting her own mental health front and center and made them relevant in a court case. She told the court that she was harmed and that she could prove it, but that left her open to being forced to come up with real evidence, and that means therapy notes, medical records, diagnoses, that she probably thought would never see the light of day when she first made her accusations. Discovery, just like litigation, is not just a paperwork exercise. It's where skilled litigators start to pull at the threads of your case. If your claim isn't built on solid ground, discovery will find the cracks, and when those cracks are found, your whole case can fall apart. Litigation is often entirely won or lost in discovery. You may have in your mind's eye the idea that you're going to go to court and prove your case like in the movies, but you can lose your case and spend thousands of dollars in the process in discovery before you ever get to court at all. So at Fausone and Grysko, we take a very conservative approach to litigation. We always tell our clients, be careful what you put on the record and make sure you go into litigation with your eyes open as to how expensive, long, and emotionally draining litigation can be. Emotional distress claims, for example, aren't just something you throw in because you want to stack the deck against your opponent or because it sounds cool. They require real documented harm. Without it, you risk not just losing your case, but exposing your personal life, medical history, and credibility to intense scrutiny. Only file what you can prove. Avoid litigation based on emotion or revenge alone. Avoid dealing with attorneys who want to push you into litigation and call themselves the pit bull or an attack dog, because those are often attorneys that will get you into a process that you can't get out of easily, and they're doing that for their own benefit and not necessarily for yours. Go into litigation with your eyes wide open, because once you get into litigation, it can be harder than you might think to get out of it.